Welcome back, everybody, to another lesson in the law of trusts. This lesson we're talking about further trust formalities, specifically the formalities in the creation of inter vivos trusts. This is a carrying on, a continuation from the previous lesson where we talked about how trusts are made through the use and execution of a will, sometimes known as testamentary trusts. This lesson is going to talk about trusts which are created inter vivos. So, specifically, we're talking about the formalities which are required for the creation of an inter vivos trust, which is of property which is not land. Now, obviously, the reason why this is the case, as you would probably imagine from the fact that I've cited this here, is that when we think about the creation of an inter vivos trust in property that is land, there are different requirements, and those requirements are, of course, governed by the Law of Property Act, some of which are actually quite complicated, which we're going to get to in future lessons' time on in the formalities of a trust. We have to make a distinction because there is separate formalities which are required for trusts which involve land versus trusts which are just involving any other kind of property, whether that be realty or shares, etc., etc., etc. So, as a basic recap then, what is an inter vivos trust? An inter vivos trust is simply one which is created and is made effective before the death of the settlor, so when the person is a testator instead. And so this is unlike the idea of a testamentary trust, whereby you are talking about an individual who has died and the trust is created at the execution of their will. This is one where the individual is still alive and wants the trust to not only exist but to be effective before their death. The formalities in relation to the creation of an inter vivos trust, as you should be quite happy to know, are quite simple. If an inter vivos trust is sought to be created, then the creation itself involves the property that is not land, specifically any other property that doesn't concern land. This video does not concern itself with the creation of an inter vivos trust in land. Then the only formalities that are required are the three certainties. So long as you have the three certainties, you can therefore establish the creation of an inter vivos express trust in any property that is not land. This is quite nice because you should be familiar with and remember what the three certainties were. The three certainties are the certainty of intention, the certainty of subject matter, and the certainty of objects. We will finish by just recapping what these three certainties actually meant. The certainty of intention refers to the fact-finding mission, which is done by the courts to ascertain whether or not the instrument which is alleged to be a trust in question was actually intended to be a trust and was not intended to be some other kind of instrument, like, for example, a gift. So, a lot of the cases involving certainty of intention requires ascertaining from the language and the wording of the trust instrument itself whether or not that meant that they wanted to create a trust or whether or not they wanted to create a gift or create some other kind of instrument which does not have the effect of becoming a trust. Certainty of subject matter refers to the property that is alleged to have been put on trust. So again, I say alleged because we're talking about circumstances where we are trying to determine the existence of a trust. And so therefore, when we think about this, we have to say that it is an alleged trust, given the fact that it is not conclusive until we have determined through the various different certainties that there has been a trust and that it has been created. So the property itself being put on trust, according to the certainty of subject matter, the property which is left to the beneficiary must be easily identifiable. So the property that is taken, put on trust for a beneficiary has to be identifiable. And we can remember back to various different cases that illustrates these points relating to intention and subject matter. One of those includes the idea of there being, I believe it was quite expensive, wine bottles of wine that all had certificates of ownership. and it was alleged that they had been held on trust for the people who actually had bought the wine, and they were the beneficiaries of the wine. And it was concluded by the courts that because they were not easily identifiable, you could not, for example, delineate your particular bottle of wine from another person's bottle of wine. They were all the same bottle of wine. There was lots of different bottles of wine, and you just had a certificate for one of them. And so as a result of which, that failed to meet the certainty of subject matter requirement. Other examples of this nature included things like gold bullion, again being unidentifiable from the rest of the group, and so therefore did not represent the creation of a trust by way of the fact that it failed on the basis of the certainty of subject matter. Finally, then, you have the certainty of object. This refers to the people or organization or institutions who are alleged to benefit from this alleged trust instrument. Okay, so the certainty of objects requires that it is clearly highlighted who the beneficiaries are, and there are certain requirements or certain delineations and changes in the way that this works in relation to trusts for example, charitable purposes, because in circumstances where we are creating a trust for a charitable purpose, it doesn't actually matter necessarily if we do not have a specific or a non-vague certainty of objects. The charitable commissions and the courts tend to be able to alleviate that problem, given the fact, and only given the fact, that the trust itself was a trust created for a charitable purpose. We'll get to that more in the next topic. But for now, this is the creation of and how we can create the inter vivos trusts for any property that is not land. And so the next lesson is going to concern itself with the types of properties, the types of formalities, should I say, for the creation of trusts which do concern land, which include more than requirements relating to just the certainties of intention, subject matter, and objects.